Hey out there, legal warriors. What is the realistic timeline for getting a domestic violence no contact order dropped? That's a very common question we get in my office, and I'm going to cover it in this video. So if you're interested in this area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 20 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get to see it. More people get the help they need. Now I'm just going to jump right into it. What do I mean by domestic violence no contact order? That does not mean a civil protection order, a civil domestic violence protection order where the petitioner is filed for protection from a respondent. It sounds the same, but a domestic violence no contact order comes from a criminal case. No contact order is different from a protection order. We might all just call it restraining orders, but that's sort of sloppy speech. So a domestic violence no contact order means someone has been arrested or charged with a crime of domestic violence, and the court has issued its own no contact order saying, hey, defendant, you cannot have contact with the alleged victim of the crime. And usually those are issued over the objections of the alleged victim. Most domestic violence cases in Washington State that we see are domestic violence assault in the fourth degree, a non-felony. Any type of unwanted touching, striking, hitting, could be throwing a beer in someone's face, could be really serious sounding, might not be so serious sounding. Obviously all crimes are serious, but there's different, ways it may hit the court. And the court will say, we're going to issue a no contact order, the court is, because we want to separate these parties and we want to protect the alleged victim because the court has found probable cause, reason to believe that the defendant created a crime when they read a police report generated by a police officer when someone called the police. And so at that first court hearing, the no contact order is entered. It may be carried over to an arraignment hearing where now there's going to be an official reading of charges, or that first hearing sometimes is the arraignment hearing. It depends on who the plaintiff is. And if you've watched my channel for a while, you may be able to figure out those situations. It depends if it's a city case or a county case. And oftentimes that order is in place, like I said, even though the victim doesn't want it. And we get these calls either from our clients or from alleged victims going, hey, Law Office of Lance Fryrear, how quickly can I get this order dropped? Can I get it dropped at the next hearing? How long is this going to last? I'm not in my house, etc., etc. And as you know what the answer is going to be, the answer is going to be, it depends, because every case is unique. But I'm going to cover, what factors here can have an effect on how long that order is going to last. What is the reasonable amount of time before it gets dropped? Usually, if I was going to pick a rule of thumb, the quickest I see anything dropped, if it gets issued at the arraignment or first appearance over objection of the victim, is a couple of months, right? What? A couple of months? That's pretty normal because that first court hearing after the court has issued the order is usually 4 weeks, 6 weeks or more out just due to court congestion. That's a pretrial hearing. Many cases, it's going to go on for many more months, past 2 months. And so how does it work? Well, the order's in place in this hypothetical and the alleged victim doesn't want it. So the alleged victim either tells the victim's advocate, somebody who is supposed to communicate between the prosecutor and the alleged victim to make it, supposedly better on the alleged victim. In my opinion, that's not usually what's really going on, but that's for another video. And then the alleged victim will either be told how to note a hearing, fill this out and ask for a hearing to address the order, or sometimes the advocate can do that. Or sometimes they'll tell the alleged victim, just go to the next court date and ask yourself without filing something. Typically, that gives the court an easy out. Well, nothing's on file, so I don't need to address it today. So that's probably not the best practice. But once that alleged victim requests that the order be dropped or modified, hopefully in this hypothetical, the court is going to set a hearing. And most courts will require that somehow the defendant be notified of the hearing. Some courts will say, alleged victim, you tell the defendant because you're allowed to communicate. That can actually happen. I don't know how that's possible, but it does happen in certain courts. Or more likely, the court will send a notice out to the defendant or the defendant's counsel, their attorney, saying, hey, this is going to be addressed at the next hearing, and here's what the alleged victim filed about the reasons why the alleged victim, him or her, wants to have this order dropped. Now, will the order get dropped at the hearing? Well, it depends on certain factors. The first factor it depends on is, what did the alleged victim write? Did the alleged victim write stuff like, let's say it's a guy who wants the order dropped against his wife. I really love her. I really need her at home. I really depend on her, stuff like that. Those things are less likely to be successful because it sort of activates, in my opinion, the protective function of the court. One of the theories of domestic violence is that if the victim is dependent on the suspect, they're more likely to change their position, disregarding their own safety because of their dependence on the suspect. If that request to drop the order says, hey, I'm financially independent, I know how to take care of myself, please don't rob me of my agency and making my own decisions about who I associate with. And I'm also not concerned because I've learned through defense counsel that the defendant has done some anger management classes, or is in domestic violence treatment, or is in alcohol treatment. That sounds more reasonable. It's less likely to activate that protective function in the court's brain, right? Because it's just a human making a decision. And if you've watched this channel, remember there's very little in it for the court to drop an order while the case is still going on. There's very little in it but risk for the court. There's just risk for the judge. If I drop that order early and something bad happens to the victim, I'm going to be the one in the paper, right? If I'm the judge, why did you do this? Why didn't you protect the victim? It's a lot easier to just have a policy. No, it's too soon. But what the person writes is factor one. I think factor two is what has the defendant done to change, in this example, her position since the original order was issued. The court might say to the alleged victim, well, I already made this decision. Why should I change my mind now? And because I'm not going to look what the alleged victim has done, because I'm the court, I don't blame the alleged victim for anything. It's a bad look, right? Instead, they're going to look to the defendant and say, what's different? Well, if the defendant has an attorney, the defendant's attorney has helped the defendant be aggressive in trying to prepare for this, perhaps the defendant has done some classes. Maybe they've done an anger management class, the domestic violence victims panel. Maybe they're enrolled in DVMRT. Maybe they've had a domestic violence evaluation. Don't typically recommend those, and there's other reasons for that, but maybe they've done something. So now the court can take a look at the proof of what was done and go, oh, well, now I have some cover. If I really do want to drop this order, I think it's best for the family, it's best for the situation. Now I have some justification if it goes wrong about why it was reasonable for me to drop the order. Remember, this is all about human behavior. And when and if a court is going to listen to what the alleged victim wants, because really, if we were to think about it logically, they're living their own life. They should get to decide. Isn't that what we think? But no, this is an offense against the people. It's an offense against the government. And so the people want there to be an order so we don't have any more law breaking around here, right? So that's factor two, is what is the defendant? And I think factor three is, how long has it been? The longer it's been while the order in place, the more likely the court is going to be willing to consider dropping the order, especially if there's been lawful behavior. More stuff can have happened. There can be more treatments happen. Things have cooled off. They might look at how many other times that the alleged victim has requested to drop the order and it's been denied, because it's just human behavior. You get no once, get no twice, maybe the third time you get yes, right? You might ask for something again and again. Usually people give in. That's another thing they're going to consider. And there's a wild card in there. Number four is the attorney involved in the case. If they've been around the block and they've been around a while, or their law firm has, they're going to know sort of the general odds of any particular judicial officer, judge, commissioner, whatever, what their take is on dropping orders. Okay, there's certain judges that just like to do it piece by piece. Right? Piece by piece. Well, I'm going to allow this and I'm going to allow this. Some courts are, no, it's all or nothing because I don't want to mess up law enforcement. Some courts are, well, I have a policy that once you've done X, Y, and Z, it's unwritten, that I'm likely then to drop the order. Some courts are like, I just do whatever the city tells me to. That's not what they say, but that's how they act. Your attorney, if you wonder how long this order is going to last, if they're experienced, they're going to have an idea about how long it will last in any particular case. So they're also going to know what the prosecutor's like, right? They may know that a certain prosecutor won't object to dropping an order if X, Y, or Z happens, and they may know that that judge just goes along with what the prosecutor says. So it's going to take a while to get it dropped. It's not going to be fair. It's not going to be fun, but there are things we can do to try to predict it. And, it's unique to your situation. It's unique to your criminal history. It's unique to your prosecutor. It's unique to your court. But you can see with all the moving and complicating factors, if you have good counsel, they're going to help improve your odds. We can't control it. We can influence it, and we can have, hopefully, a good idea how to get everybody back together if that's what they want, sooner rather than later. So I hope you found this useful. If so, please like and please subscribe. More people get to see it. More people get the help they need. And more importantly, if you have a criminal matter in Washington State, feel free to reach out to my firm. We get on board. We'll listen to what happened. We'll identify a way forward, and we will be there for you. Thank you.